All right, good afternoon นะครับ everyone. How are you today ครับ Are you good? Okay, I hope that all of you are fine today นะครับ So today we are going to talk about module number 7 นะครับ It's about the ethics นะครับ for the e-commerce. So let's do like this นะครับ As I told you on the last class, we had one volunteer and one assigned students นะครับ So in this one we have Natnisha นะครับ and Phillips นะครับ to present the open case of module number 7 นะครับ and then I just like assign 3 of you more นะครับ for each inside case นะครับ you don't have to present now but you have to prepare นะครับ before because I mean like whenever I just like talk about whenever I talk about that case นะครับ I'll just let one of you the name of the presenter to present that one นะครับ okay so for case number 1 นะครับ oh you want to Sujina want to volunteer inside one okay that's okay Sujina you can just like go for inside case number 1 นะครับ anyone would like to volunteer for inside case number 2 okay if no นะครับ case inside case number 2 can I assign นภัสนะครับ นภัส to present case number 2 when we reach that case นะครับ andจิรายุครับ hang on จิรายุ I think you present on the last chapter already I remember พงศกรครับ พงศกร please present case inside number 3 นะครับ when we reach that case so that means สุจินา นภัส and พงศกรนะครับ please stand by นะครับ when we just like reach that inside case I'll just like let you summarize the case for us first before we start talking about the discussion นะครับ okay right okay then นะครับ so okay Philip is here already not Nisha okay you are here too so firstly ครับ I would like Philip I would like Nisha นะครับ to just like talk about the case study นะครับ the open case for module number 7 ครับ Nisha ครับ please start talking about the open case of module 7 please I share the screen for you. You don't need to have any presentation นะครับ okay just one below yeah okay ครับ you may start
Okay, so the Court of Justice of the European Union or the CJEU forced Google to remove certain search engine query result in Europe in June 2014. They give individuals the right to request the removal of certain links to personal data found through their name search. The CJEU's ruling is known as the right to be forgotten or right to delist. The judgment by the CJEU ruling could be beginning of a new era in which people have the right to control their personal information and public image on the internet. Google, Facebook, Twitter, and other internet-based companies in United States whose business model are virtually unrestricted on the collection and use of personal data strongly defies the idea that individuals have a right to manipulate personal data online, but CJEU had made Google, Yahoo, Microsoft, and others to use the rule. Thousands of Europeans have asked Google to erase the links to their identities that they feel are unsuitable or invalid and interfere with the personal space. The EU standards and privacy laws did not apply because the server supplying results for Google search in Spain was located outside of Europe, according to Google and the publication. They claimed that it was just a search engine that gives links to information held by others rather than a data repository, and it was not responsible for the quality or relevance of data held by others. As a result, Google contended that the EU data protection directive did not apply to it because it only applied to the data repositories. They also claim that individuals do not have the right under European law to ask for personal data to be deleted from search engine accessibility, and it would be really hard for them to remove those data, and it could allow criminals to change their information and escape from their criminal records. The CJAU determined in 2014 that EU data protection policies are not regionally limited and that they apply to search engine wherever their servers are located, and they determined that search engines are controllers of people's personal data within the European Union and must refer to EU regulations. However, Europeans have the right to ask search engine to remove links to personal information about them when the data is inaccurate, insufficient, irrelevant, or too much. Other rights and obligations, such as freedom of expression, freedom of the press, and to be forgotten. The CJAU required a case-by-case analysis of the type of information, the danger to individuals' privacy, and public's interest in having access to such information. The French Data Protection Agency penalized Google $111,000 in February 2016 for failing to delete web search results globally. Google have received more than 720,000 requests of the removal, 1.89 million links to online information on them were taken down in total. And based on the internet criteria they set, they have deleted around 43% of those links. However, several European privacy regulations have criticized Google for alerting websites that their links are being removed from its search result, claiming that this will draw even more attention to the links. And previously, Google had enforced the right to be forgotten in European domain search results. This allowed citizens of European nations to use googles.com domain to have information and links from European domains that were deleted. And when it comes to the privacy and the balance between managing personal information and freedom of expression and the press, Europe and United States are different. Many European countries held the decision as a success over arrogant US internet companies and their casual attitude toward users' privacy. Newspaper and technologists in the United States stress the value of a free press and warn against allowing people to hide their previous mistakes. There is little doubt that European views on privacy, particularly the idea that data belongs first and foremost to the individual, will have an impact on privacy claims and laws in the United States, especially if France demand that Google remove things from out of the sites worldwide, not just in Europe. Thank you ค่ะ
Okay, thank you นะครับนัทนิชานะครับ so Phillips ครับ could you please share us for what you discover from this case ครับ
So for the open case 7 right to be forgotten, by the name suggested, it was a law made by Court of Justice of European Union, where the main idea is that any individuals have the right to request the link to personal information found by their names be removed or altered. Of course, with the law, many US internet-based firms were against it, but because of the decision of the European laws was final, they have to follow. The main concern to these companies are it's hard to implement, and of course, it is costly to remove all the links or data. The lawsuit that made this law came to life is made by Mario Concecha Gonzalez, a Spanish citizen. The incident was that his name was linked to an auction notice indicated that his house was sold to a pay debts. But actually his debts was done for years. So the data that is linked to were irrelevant. This harmed his reputation and his working ability in terms of how his coworker will act, which is his main concern. So he requests to remove or alter the post and unlink his name and notice. After the incident, there are not only just him requesting Google to remove the link, but also other thousands, even millions of Europeans sending the same request to Google. After the court has made that decision of the law, the Google's made a response is that their servers is outside of Europe, which means the EU laws didn't apply. Secondly, search engine only provided a link related, not a data repository. So it's not their responsibility for accuracy or relevance. Also, EU Data Protection Directive works only on data repositories. Lastly, under European law, individuals cannot request to remove accessibility of search engine. They also say that it's impossible to respond to all requests. This might make criminals to rewrite their history and limit innovation to the future. In the opposition to that, Court of Justice said that policies weren't territory limited, which means the server argument wasn't valid. It's also applied to search engine, where they view the search engine as a controller to the personal data. In other words, a processor of data over the internet. Last argument made by the Court of Justice is that individuals have right to be forgotten when information is inaccurate, irrelevant, inadequate, and excessive. However, with the right to be forgotten is published, it's not considered absolute. Criminal records cannot be altered or removed for the safety of the people. And the law will be balanced with other rights and obligations. It will be processed but with case-by-case examinations. Despite removing requested links, Google still got criticized because they informed the website about removed links, which raised more attention to the public. In response to that, United Kingdom ordered Google to remove the news about the links. And other criticisms are that decisions should not be made by one private company. This is where France Data Protection Authority came in. Before, Google only filtering the listed link on some of the European countries' domains, which means many Europeans can still access those links using the main google.com domain. So they have migrated from doing for just only the European domains to all of their domains. Other search engine companies such as Microsoft, which has Bing, also followed to avoid having the conflict with the European courts. However, one can argue that people can search through online newspaper archives to find the same data that's said to be removed. And new data storage techniques like blockchain are hard to manipulate, which is their strong point. However, in this case, this can be a little tricky to the companies. Lastly, we can see that Europeans' view of privacy and security differ from what US firms are thinking. If the right to be forgotten and France Data Protection Authority could spread the same ideas all over the globe, this may impact on US privacy claims and laws. Thank you. Hello.
Okay, thank you. Thank you, Philip. Right. So now you can see that your classmates help us to summarize and share us like what they read from the Europe's leads on internet privacy case with like some websites like Google something like this. Now let's see for the case that we studied okay. All right. So in this module, you can see that I open the case open this module with a case about the ethics that and also like the political issues in terms of the e-commerce that we may be confronted with especially if you would like to set up the e-commerce in specific countries. You have to think about like the ethical issues that might happen as well and also the laws that they govern in that country for help protecting their people from like the privacy, let's say. And you can see that even in Thailand right now, they have the law that is like PDPA or the personal privacy information that the e-commerce website and platform has to know and has to follow. So in this one when we start with the open case okay for this one I'm just wondering is Google responsible for the accuracy of links to other information? Why or why not? Can somebody just like help answering in the chat box Is Google responsible for accuracy of links to other information? Why or why not? Not Nisha, what do you think? You are the expert of this case.
I think that they are not responsible uh, for this because like I guess that there are many links globally, and if Google have to be responsible for all of this of this thing, it would be like a very huge works for them.
Okay. Atiwat gives us like the idea is that Google is responsible for at least for making it more widespread by having it on first few search results only. What about yeah. Somebody want to talk?
Oh no, it's just me. You want to finish what you said first, or?
Yeah, you just like continue, Atiwat.
Okay, so the idea is that Google is at the very least, even though the whole database that people put on the website is not, everything is not to the responsibility of Google. They're the one who manage the search engine where a lot of people will access it and a lot of people will see it. For example, if you Google something, then the first few search results, the top search result will be the one that millions of people around the globe is going to be the one to see. So it kind of follows the same logic as how famous people like politicians
Excuse me, Atiwat. I couldn't hear you clearly. Could you please speak louder and closer to the microphone? Thank you.
Is this better?
Yeah.
Okay. So so my point is that it kind of follows similar to how politicians, actors, and celebrities and famous people are expected to give accurate information when they say something, because whenever they say something, it became very famous and it became very popular. So if they say something that is not accurate or is misinformation, then it's going to spread to a lot of people and it can do a lot of damage. Google is the same way. They're not responsible for every data, but they're responsible because if the search engines put some misinformation on the first top search results, then millions of people will see it, and it's going to cause a lot of damage by spreading more misinformation. So at least they're responsible for that part. That's my opinion.
All right. Okay. Thank you, Atiwat. What about others? Do you have any other ideas to share? Okay, if not, let's move on to the next one. Why do European and Americans' views on privacy protection differ so dramatically? What do you think? Philip, what do you think about this? You are another expert of this case. What is your idea?
So the difference between Europeans and Americans is that Europeans put the right of the individuals before any business interest, while the US actually worried more about the integrity of the data as a commercial asset. They value more of like the data with the personal information which they can use in their businesses. These views are like obviously very on the opposition of each other. I believe that because they have a strong view on different position, they will constantly have this argument over and over again. And also Americans are really worried about having criminal record, which means most of the data are not able to manipulate to remain the history of that links to the person.
Okay, yeah. That should be like the main reasons, right? Any other people would like to support what Philip mentioned? So you can see that Europeans, they are quite conservative, while American, they are liberal. So that's why they're just like quite different in terms of the point of view in, I mean, most of the aspects that they just like propose, right? Okay, now let's move on to the last question. How can different perspective on privacy be managed in a global environment like the internet? What do you think, Atiwat, can you share us your ideas?
Okay, so the thing is that if we look at how it is in the current day today, like how it already is, then basically what happened is that even though the internet is global, each country has its own law to block whatever it doesn't want, or have a basically if some website or companies cannot abide by it, then they'll just straight up block that website, or just basically have some agreement where the companies may set up a different sites or different platforms on each country. Take China, for example. A lot of companies that we see as global, like Facebook and Google, are not available in China, or even if some companies are available, then they are subjected to heavy regulations to this. So even though we say that it says in the question that it's a global environment, it still isn't that global because government can still basically regulate it a lot. And in some severe cases like China, it basically creates its own environment altogether. And I think that is kind of becoming a trend actually, with government becoming like more tech savvy, and in that case, yeah, also putting more regulations on what internet can be accessed or what it cannot be accessed in each country. So that's the way it already is managed in each country. But when it comes to privacy, then yeah, we can talk about different like ways where we can pursue it if the way that the government control is not really that good. But yeah, this is just a gist of it.
Okay, so this is the example of the ideas from Atiwat, but actually you can see that if you would like to have the global level for the privacy management, it is like quite difficult, except like each country set up its own like regulations or law, and then they need to just like talk to each other, talk with other countries as well in terms of like the privacy law, or you just like use the standard of like some country that they set up before. For example, if you think that, okay, American people, they set up the privacy level, that is good enough, then you the country may just like or the government of a specific country, like in Thailand, they can just like have a look, and then they can just like use some clause that is useful for the environment, like in Thailand, in order to set up the law about the privacy as well, in here. So these are just like the open case that you read, and we found like something that is like quite interesting in this case. So now let's see. The next thing that we have to know is that, okay, for the ethical, social, and political issues in e-commerce here, we found that internet, like other technologies, it can enable new crimes. It can affect environment, and also it can threaten social values. So cost and benefit must be carefully considered, especially when there are no clear-cut legal or cultural guidelines. And you can see that for the internet environment, it is not clear-cut. Because I mean, everyone in the world can access to the internet, can access to the website of other countries as well. So that's why, for example, if your country set up the legal issues and set up the law to against something or ban something, then people who just like set up the e-commerce website might just like relocate their server in another countries and use cloud server instead. You can see that this one is not just like in the what to say in that country anymore. So the law cannot be just like used to control, the law of that country cannot be used to control the website that is just like not in that country. It might be from the offshore ones, something like that. the next one นะครับ when we talk about the model for organizing the issues that we may have นะครับ issues raised by internet and e-commerce can be viewed at นะครับ three different levels that are individual, social นะครับ and ethical social and political levels นะครับ there are four major categories of issues that are information rights, property rights, governance, and public safety and welfare นะครับ it can be viewed in this model like this one นะครับ this is the moral dimensions of internet society นะครับ we have three different levels, political, social, and ethical issues นะครับ inside is the internet and e-commerce, and we have four different aspects that are information rights, property rights, governance, and public safety and welfare that you have to consider นะครับ these three different group of issues นะครับ in different aspect นะครับ or in different dimensions นะครับ so when we talk about these internet and e-commerce impacts on individual society and political institution already นะครับ the next thing that you have to know is about the basic ethical concepts that you have to know นะครับ basic ethical concept that you have to know so that we can define issues in terms of the ethics easily นะครับ ethics นะครับ ethics is a study of principles used to determine right and wrong causes of action นะครับ the responsibility, who is responsible for that one, who is accountable for that one นะครับ also liability นะครับ for liability in terms of ethics we think about the laws นะครับ that permit individuals to recover damages นะครับ for example if นะครับ the company นะครับ did something wrong to its customer นะครับ how the law นะครับ permit individuals to recover the damages นะครับ and due process, for due process laws are known and understood นะครับ in order to just like use or apply that one to a specific case the law must be known นะครับ the law must be known and understood, and ability to appeal higher authorities to ensure laws applied correctly. That means if you bring the case to the court นะครับ normally we just like start with the court of justice first at the first level. So when the court of justice make a decision on this issue or on this case already, and if นะครับ the person who get the damages นะครับ cannot be compensated properly because you might think that the court might not see like some evidences นะครับ properly, you may be able to appeal to the higher authority นะครับ so in this one we call the next level as appeal court นะครับ okay, and then you can just like appeal that case to the higher level court once again so that they can just like see for all the evidence that you submitted before นะครับ has a point or not, that can just like maybe able to change the decision making of the higher level of court นะครับ but if the second level of the court, that is what we call Supreme Court, cannot judge นะครับ the final decision, for example if they still insist that okay what the Court of Justice mentioned is correct นะครับ if you have like damage caused by another person, you may be able to just like bring this case to the highest level of the court, that is the what we call Supreme Court นะครับ in order to let them just like finally judge what should be done นะครับ what action should be done properly, something like this. This is the due process นะครับ but anyway for the laws นะครับ they have to state clearly, otherwise you cannot just like bring that case to the court. These are just like the ethical things นะครับ or the concepts that you have to know. Okay, because for the ethics actually they have to just like be valid and the court นะครับ just acknowledge this kind of thing นะครับ in terms of just like for example when we talk about the e-commerce นะครับ in Thailand there are a couple of the ministry that just like prepare and enact the law นะครับ starting from just like the Ministry of Commerce นะครับ in Thailand นะครับ whenever you have to set up the new e-commerce website นะครับ you have to identify yourself. You have to register with the Ministry of Commerce first. Also, the information that has been transferred and exchanged between the e-commerce website, customers, and other stakeholders. The digital economy ministry has to be responsible for this one. And also in terms of money that you get from your customers, the tax that you have to pay, in terms of the e-commerce, that because you are the business, you have to deal with just like the tax office, the taxation office. In Thailand, we call it as the revenue department, or what to say, กรมสรรพากร something like that. That is just like they just be the another authority in order to just like set up the law about the payment of the tax for the income tax, sales tax of the e-commerce as well. So you have to take a look when you set up the e-commerce of a specific country, what laws are governed, what are authorities that deal with this kind of ethics as well. The next one that we have to think about is to analyze the ethical dilemmas. Sometimes you may have to just like confront with the dilemmas. The things that we have to do in order to analyze ethical dilemmas. These are the process. Step number one, you have to identify and clearly describe the facts, what's going on in details. Step number two, you have to define the conflict or dilemma and identify the higher order values involved. Step three, you have to identify who deal with this situation or who deals with this conflict or dilemmas. Then you identify stakeholders. After that, in step number four, you have to identify options that you can reasonably take. And then you also have to identify if you make a decision to do something, to take on the option or to choose that option already, what will be the potential consequences of that option that you may choose. For example, if you say that you have 3 or 4 different ways that you can choose or you can do if there are conflicts, then you have to evaluate the consequence of each solution first before you make a decision. These are just like the way to analyze the ethical dilemma. After that, we talk about the candidate ethical principles. For the ethical principles, these are just like the ethical principles that we see around the world that we may use, that I'll talk about next on. You may use golden rule, universalism, slippery slope, collective utilitarian principle, risk aversion, no free lunch, the New York Times test, or the social contract rules. These are just like ethical principles that people use around the world. So when we talk about privacy and information rights, the privacy and information rights, privacy here, we say that, okay, moral rights of individuals to be left alone, to be free from surveillance or interference from other individuals, organizations, or state. For example, suppose you say that, okay, right now you are on Zoom, we are on Zoom, let's say. And if you say that, okay, you are sleeping while I'm teaching here, even though I can see that you are sleeping, but I don't say anything because it's about your privacy, you have the right to sleep. But I mean, like when I ask you for some question, you have the responsibility to answer anyway. These are just like the privacy, the basic privacy that we have to know. Or when we talk about like the ATM machine, let's imagine of ATM machine. Suppose you just like go to withdraw the money for, let's say, 500 bahts from the ATM machine. Once you can see that none of ATM machine speaks out how much do you have left in the balance of your account. For example, if you say that after you withdraw 500 baht from the ATM machine, you have 100 baht left. You will never hear any ATM machine speak out that your balance is 100 baht left. Thank you for using our ATM. You don't see that, you don't hear that one at all because it's a privacy. You can see that you may have the question that what about the people with the eye vision impair, what should they do? They can have, you can see that when you go to every ATM machines, they have like the ear jack, the ear plug for you can use just like the earphone to plug into that ATM machine to let ATM machine to just like speak. But you can see that ATM machine normally they have the speakers, but they never speak out anything about like the balance, about like even you press the pin code wrongly, it doesn't say anything. It just like show it on screen because that one it is private enough for just you to have a look. Except if you say that, okay, somebody just like try to sneak and just have a look what you just type in, that one they just like violate your privacy anyway. But I mean like ATM machine itself will not just shout out and let other people hear for what you just like type in. That is about the privacy of the users that we have to know. For the information privacy, they have 4 premises for the information privacy. The first one, right to control information collected about them, or we call it as the right to be forgotten. That means, I mean, if you just like do some transactions with the e-commerce website, and if you would like to delete your account or unsign up or just like deactivate the account or remove the account, you should have the right to do so. That is the right to be forgotten. Next, right to know when information is collected and give consent. This one you should have informed consent. Normally, each e-commerce platform should provide the consent to your users. And I think you usually see them, but you might just like scroll. You might scroll down and then just tick that you understand about the consent already and you accept it. That is the consent. It must be informed. That means some website or some e-commerce platform, they are quite good. They don't allow people to just click cancel. They just like have to allow the users to scroll down and until they see the checkbox to accept and click accept or click OK, something like that, rather than just close the screen. The next one, the next one is right to personal information due process. Right to personal information due process. Okay, you can just like process your let's say if you sue this case, something like that. Okay, this is must be allowed. And the last one, right to have personal information stored in a secured manner. So that's why you can see that right now most of the important or most of the leading websites, including Google as well, when they keep the information of the users, they just have to, they use like the HTTPS protocol with the encryption. So this one, they can claim that they have information stored in a secure manner already. All right. So next one, when we talk about the FTC, the American American Federal Trade Commission, this is FTC. This is FTC Fair Information Practice Principle. The first one, for the notice or awareness. This is a core principle. The description of notice and awareness is that sites must disclose their information practices before collecting data. Includes identification of collector, users of data, other recipients of data, nature of collection that are active or inactive, voluntary or required, consequences of refusal, and also steps taken to protect confidentiality, integrity and quality of the data นะครับ This is notice awareness นะครับ one of the core principle of the FTC's fair information practice. The next one is also the core principle as well นะครับ It's about choice and consent. There must be a choice regime in place allowing consumers to choose how their information will be used for secondary purposes other than supporting the transactions, including internal use and transfer to third parties. Opt-in or opt-out must be available นะครับ For example, if you and your friends นะครับ run the e-commerce websites นะครับ two different websites, let's say. Firstly, if you say that when you have the customers, you will send or you will pass that customer's information to your friend's website so that your friend can promote their product นะครับ to these customers. This one is not okay นะครับ This is the customer must have the choice and they need to have the consent as well in order to just like use that information for other purposes. You can see that another website or another e-commerce platform is not related to that business transaction at all. For example, if you say that you sell the hardware นะครับ your website sells the hardware while your friend's website sell the software. You can see that you think it should be good for the customer. When the customer purchase the hardware, they will need to buy some software as well. Then you pass this information to your friend so that they can advertise the software to your customer and you think that is good. Yeah, I know that is good, but the customer must have the choice. You may say that, okay, will the customer allow our website to pass this information to another website for commercial, for marketing purposes or not? This one they can choose. If they are not okay, they can just like opt out. This is a choice and consent. Next is about access and participation. Consumers should be able to review and contest the accuracy and completeness of data collected about them in a timely and inexpensive process. In terms of security, data collectors must take reasonable steps to assure that consumer information is accurate and secure from unauthorized use นะครับ This is security. And the last one is about the enforcement principle นะครับ For the enforcement นะครับ there must be a mechanism to enforce FIP principle นะครับ in place นะครับ This can involve self-regulation, legislation giving consumers legal remedies for violation นะครับ or federal statutes and regulation. This one has to be conform with just like the law of that specific country as well. And this one is the American ones. So that's why they just like try to engage this one with the federal statutes and regulations or law as well. So when each country has to set up the fair information practice principles, they just like normally have to just like declare this kind of principle with the description. After that, when we talk about the privacy in the public sector, that is privacy rights of citizen. This one we talk about the macro level. Public sector privacy rights have long history. This is from the American. They had like First Amendment, Fourth Amendment, 14th Amendment, and constitutional. They imply privacy rights that did not cover collection and use of personal information. And in 1974, American just like had their privacy acts. And federal and state laws, they set up to protect individual against unreasonable government intrusion. In different countries, they have like the privacy law of that specific country as well. Okay. And in terms of consumers นะครับ privacy rights of consumer American set up the privacy นะครับ protection นะครับ or the privacy right for the consumer as well. They said that privacy issues rose with first large-scale nationwide computerized system like credit card system, like credit card bureau นะครับ credit rating agencies นะครับ piecemeal federal and state privacy legislation นะครับ This is the name of the law นะครับ applying to specific industry like Spokio's versus Robin case. This one, what harm must be shown in order to sue. And they say that historically, field claims through privacy in public open markets such as in e-commerce นะครับ And they say that emergence of internet has created enormous collections of personal data นะครับ This one is the ideal environment นะครับ for business and government to invade personal privacy of consumer. For example, for Google, you can see that we use Google every day นะครับ on almost every activity we use Google นะครับ including searching for some information in order to navigate us to go somewhere นะครับ in order to just like go to some website and Google collect the data because you use Google Chrome นะครับ something like that. This one you can see that lots of personal data flows to Google นะครับ So the example in here like Google, Amazon, Netflix นะครับ that this one a lot of personal data comes to this website นะครับ come to this platform. And when we talk about the information นะครับ that collected by websites นะครับ you have to know that some of the data นะครับ you need to have like the identification of the customer or the person that you are using, that you are working with. For example, suppose we say that, okay, we use Google search engine. If you just like use your device to log in, นะครับ for sure, they have the your personal identifiable information นะครับ Hang on, Atiwat asked me that on privacy laws part, can you give equivalence for Thailand? Right now, Thailand is like it's in the infancy stage ครับ They just start having the privacy law นะครับ not long ago, and it's not settled yet. They just like launching a bit at a time. For example นะครับ the latest law in Thailand, they talk about the latest privacy law in Thailand. It's launched on September the 16th, if I'm not wrong นะครับ September the 16th, 2 months ago, talking about the privacy of the data of people when you just like post something on the internet. I'm sure that you may have heard that, okay, if you are just like try to just like say something bad for other people, they can sue you, right? Okay. Now, talking about the privacy law นะครับ if you post some pictures or messages in Thailand that has the information to identify a specific person, you do something wrong already. For example นะครับ if I know that, okay, Atiwat said that today he has class all day นะครับ okay, let's see, this is the thing that I get. Atiwat said that he has class all day on Monday, but นะครับ I said that, okay, when I finish teaching you นะครับ at 2 p.m. I just drive to buy a cup of coffee นะครับ and I saw that Atiwat just park his car in front of a restaurant นะครับ and then he just what to say, sip a cup of coffee นะครับ and enjoy what to say, playing games with his friends นะครับ in that restaurant or maybe in that club, let's say. Then I decide to take a photo of his car นะครับ and then tweet it and say that, oh, this one, he told everyone that he has class for the whole day, but how can he just like playing games with the friends in cafe? This one, he just like, he's a liar, let's say. And then I just take photo of two things. The first one is Atiwat's car with his license plate number. This one, I'm committing the crime already about the privacy law. You can see that the car with the license plate, actually, even though you said that, okay, but anyone can have this car. Yes, maybe, but not everyone can have this model of car with this license plate. Or I said that, okay, another privacy law is that I take a photo of student ID card of Atiwat, let's say, and share it to the internet. I tweet it and I say that, oh, I'm so proud, this one is a superstar in Thailand, and I take your photo your ID photo. This one I'm violating your privacy as well. I'm breaking the law in Thailand. This is the example of the privacy law that you have to know. In Thailand in terms of just like e-commerce, if we are talking about the privacy law, it's also the company cannot reveal the personal data of the customers when the customer does not sign for the consent. You cannot use that information in whatever way. The information of the customer, even you have it in hand, but you only have to use it in in order to complete that transactions that the customer intend to do only. Suppose, let's say, I say that, okay, I am a father of a girl, and I say that, okay, my daughter just like sign up, just like buy a new mobile phone, and she just like open a new phone number. I want to know that what phone numbers she called to. Then I say that, okay, I told, let's say if she is the customer of AIS, okay, I send an AIS with the my citizen ID card, my house registration copy, because in the house registration copy it said that, okay, my daughter is in the same house as mine, and the name of father and mother the father must be my name. And then I told AIS that I want to have the record of hers. This one you have to know that AIS doesn't have the right to give my daughter's records to me. Why is that? I am not the one who hold the law. If I would like to get that information, that must be there's something wrong happen. The way that I have to do is that I have to contact the police, and the one who asks for the record of the phone is the police, not me, even though I'm a father of that daughter, of that girl. You have to know this is the the privacy law in Thailand. But anyway, in details, it's still in infancy stage, and it just like have to increase more and more. Because I mean, like, the reason is because we cannot just copy everything from other countries' privacy law and use it in Thailand straight away, due to the pace of the advancements in using each kind of technology are different, and also the area that we have to apply that privacy law is different as well, because in Thailand it's just like small country. Then you use like the e-commerce websites from other countries outside Thailand. Then if you apply that privacy law, it might not be compatible to use with that or to apply with those websites. So that's why the committee that regulate this kind of law has to be careful. Okay, right. Okay, is it okay, Atiwat? Is it what you want to know? all right okay นะครับ so for the data that each website collects นะครับ or information that each website collect it is including two parts. First one is personally identifiable information or PII, and the other one is anonymous information. For the anonymous information นะครับ this kind of information is the information that cannot be traced who did it นะครับ or who used that. For example, you can see that okay one easy example is that if you go to Shopee website นะครับ if you go to Shopee website and then you don't log in into Shopee นะครับ you can search for any information. For example นะครับ okay let's see suppose I'm going to Shopee website นะครับ okay. This one, you can see that. Okay, let me just see a bit. In Shopee website here, okay, let me just like go to international websites. In here is redirected to Thai website. You can see that here I don't log in, right? I don't log in. But if I want to search for the information, in here, you can see that in here, I can click to see this product, but Shopee doesn't know who I am because this one is anonymous information, and they don't have the right to ask for me who I am. But sometimes, if you log in, this kind of thing, you can see that they know already that it's me. This is PII, personal identifiable information. So that means the information that the e-commerce collects has two parts. One part is the personal identifiable information, and the other one is like anonymous is anonymous data. So the things that you have to do is that okay when you just like declare or when you see in the law whether that clause in the law stated about the PII or it stated about anonymous information, and when you need to have the consent to let your customer to write or to sign for the consent, you have to identify these two parts of information as well. Let me give you an example. Now I'm doing a research with the medical doctors at Sirat Hospital. The things that we have done is that we are running our experiments about the game addiction kids the kids with the game addiction symptoms. The things that we do is that we just let the parents to talk to our chatbots in order to know or in order to identify whether their kids are addicted to the games or not, and how to treat or how to help them in order to not be addicted to the games anymore. What should the parents do? Something like this. So you can see that the tools that we use to communicate with the parents is Line official account. For sure, when they ask any information from the Line messenger, we know who that person is, because when there are the users they are volunteer, they have to they have to just like sign up in our sign up form first that collects all of the information. After that, we give them the identification number that they have to fill up when they would like to ask any question in the line messenger when they have to talk with us. So that means that part is personal identification information. And whenever they ask any question, we always know who he or she is. So that's why we have to let them sign the consent for that information. And also, we also have to tell them that we use it for the educational and the research purpose only. We don't use it for the commercial, and we don't disclose this information to other people. So these are just like the information that we have to let the users of the system knows. Next, when the data is collected, what are the types? Name, address, phone, email, social security, bank and credit card accounts, gender, age, occupation, education, preference data, transaction data, clickstream data, browser type. Actually, many of these information can be just like collected directly when the user just like send the information or just like browse our website, because the browser just like send lots of information to us. While some of the information, like the first 2 bullet points, we know whenever the customer or when the users just like sign up, then we know that information. And later on when they sign in, we just like obtain this information from the database as well. Apart from that one, we talk about the key issues in online privacy of consumers. The top concern for the key issues are profiling and ad targeting. This one you can see that right now in many countries, many websites try to just like avoid this profiling and ad targeting. They just like know that, okay, in the country that they set up this website, they don't have any ad targeting. So when you use their website, even though you are from overseas, for example, if their website the server is located in country A, let's say, and you are the customer from Thailand, you can see that, hey, how come we get the ad targeting all the time? Even though in Thailand, if we say that, okay, actually that we don't have the ad targeting law about the ad targeting. So that means if we have ad targeting protection law, but that website still just like use our information for ad targeting, how can we do it? Their website is located in country A, let's say, and in that country they don't have ad targeting law to protect the people in that country. So that means they don't do anything wrong, because they say that, okay, in my country I don't have any ad targeting protection, then I have the right in order to just get the information of consumers and promote them with the targeted ads. Next is social network privacy. Are also the top concerns, because right now people post a lot of things on their social network. Sharing of information by marketers, mobile phone privacy, and digital assistant privacy. These are top concerns for the online privacy for consumers. The next thing in terms of marketing, profiling, behavioral targeting, and retargeting. Profiling is like that. It's the creation of data images that characterize online individual and group behavior. Anonymous profile, personal profile, or facial recognition. That is a new dimension of the profiling. These are just like the things that you have to know, that this information can be used by marketers one way or another. Next is advertising network. Sorry. Oops, sorry. Next is personal profiles. I'm sorry. now we passed that one already. Next is advertising networks. For the advertising networks, they may track consumer and browsing behavior that you use or you spend on the web. Dynamically adjust what user sees on screen. Sometimes they might come in terms of, they call it as customization or personalization, but actually it might be the advertising networks. Build and refresh profile of consumers. These are the things that that might just like be done. And Google's new privacy policy. In this one, you have to just like also read and update the Google's new privacy policy as well, because they have been updating all the time in here. After that, in terms of business perspective here, they said that they would like to increase the effectiveness of advertising and subsidizes content. So that's why they try to collect the personal information from users to personalize anything to match with what users or customer may need. And also, they said that they would like to enable sensing of demand for new products as well. They want to know that whether customer would like to buy this product in the near future that we are going to launch or not. And the critics' perspective. This one is undermines expectation of anonymity and privacy. Also, they try to enable the price discrimination as well. In this one is for just like let the people to just like enter the information into the internet, while the e-commerce platform try to make use of this data in different aspects. After that, when we talk about the marketing in terms of profiling, behavioral targeting, and retargeting already, the next thing is about the social networks in terms of privacy and self-revelation. For social network, it encourages people to share their personal details. For example, location where you are, activities, what you are doing, or sometimes they have like some other personal information, including phone numbers, including let's say the location where your house is located, something like that. For example, how to say, for Twitter, let's say, in the past, if you would like to share where you are, I remember that around 6-7 years ago, it just like showed the exact location. That means if you click on the location that is specified in your tweet already, it just show also, it just linked with the Google at that time too, to show the picture of that location. For example, it just like show what to say, use the street view in the Google map to help. But later on, because Twitter is an American website, when America just like launched the privacy law, they said that they don't allow any website to reveal the exact location where the users is located. Since then, Twitter just changed. They just like reduce the accuracy of the location where the users are. For example, if I say that actually in the past, when Twitter's just like started their business not long, when I use Twitter and tweet something, then I just like choose the location that, okay, share my location too. It shares that I am in, let's say, I am in building 1 of MUIC. So that means if that is my house, anyone knows where I am sitting in. So it means that if I am in a small cafe, and if there is someone who would like to kidnap me, they can do it, okay, because they know where am I. So later on, when just like what to say, when federal law in America, they just launched the privacy law already. When I just like tweet something, the same thing, but I just like specify the location. I say that, okay, share my location or attach my location into my tweet. At most, Twitter will just like mention that I am in Salaya area, just that. So because in just like Salaya area is too wide, no one knows that, okay, where in Salaya that I'm sitting in or I'm posting that tweet, something like that. Okay, so for social network, it's encourage sharing personal details and post unique challenge to maintaining privacy. For Facebook, it has massive database, serving ads to users not on Facebook, and sharing information with third parties as well. So this one is what Facebook did. They, I mean, like from the federal law in America, they try to just like reduce this kind of thing, but some of them are just like still valid. And they say that personal control over personal information versus organizations' desire to monetize social network. Because your information, they can sell it to other companies. When you grow up, you will just like see some more information that has been just like sold to other people. For example, when you just work with a company, let's say, you might receive like lots of mobile phone, you might receive like lots of phone call from people who would like to sell insurance policy to you, who would like to get like some direct sales to you, who would like to give you some loan, let's say. These are just like the information that is sold to other people. Some of the companies, when you just like register or sign up on a website, they may just like sell your information to other companies. Or when you just like go to like, let's say, if you go to like some shopping center, sometimes they give you like some member cards or whatever thing, but you have to just sign up by writing down the information first. So sometimes that information can be sold to other people. I remember that 5 or 6 years ago, one contact, like like the name, together with address and phone number, and other information of that person, especially when you just like enroll for some membership, something like that. That one costs around like 10 baht to 15 bahts, so that they can just like sell other products or services to you. The information will be sold to like maybe another middle person, and then they resell that information to a company who just like match with that data. Okay. Next, we talk about the mobile device, about the privacy issues. In terms of mobile device, mobile apps, funnel personal information to mobile advertisers for targeting ads. Because like for your mobile, it's just you only who use that device. So exact information is like filtered, is funnel to get just like targeting ads easily. Track and store user location. Track users use of other apps as well. So these are just like the thing that may happen. So that's why on last version of iPhone, I think iPhone 12, they just try to promote or leverage the privacy when using iPhone rather than just like any other phones. Actually, they want to mean Android phone, because like they don't easily release your user location or use of other apps or personal information to other applications easily. In here. And next, persistent location tracking. US Supreme Court, they rules that police need warrants prior to searching a cell phone for information. That is in the US, but in Thailand it's different. The police can just like track your location straight away นะครับ but anyway they try to just like be the standardized if the police would like to get that one they have to request the warrant from the court first in order to do that one but in the past it's not police just go to AIS go to DTAC or True to just like track for your cell phone information straight away in here next when we talk about the consumer privacy regulation the FTC Federal Trade Commission in America in US they try to have they set up the FIP principle of fair information practice principle they need to have informed consent opt in and opt out to choose whether they allow this information to be reviewed to other people or you may just like cancel the transaction you don't want to do it anymore harm-based approach do not track mechanism these are just like the tools that FTC tried to launch recent emphasis is to give consumer rights regarding collected personal information disallow the website or e-commerce website to use that information so that means if you would like to best your customer in America you also have to check this kind of the consumer privacy regulation as well okay next for the FTC they also set up the new privacy framework as well to set the scope to apply to all commercial entities and privacy by design they said that companies should promote consumer privacy throughout the organization and at all stages in the development of products and also for the simplified choice companies should simplify consumer choice otherwise if they just like make the customer or consumer to be confused by just like providing very long messages very like complicated choice the framework for FCP try to clarify this and they try to make the e-commerce to have greater transparency okay so for the consumer privacy regulation for the FCC Federal Communication Commission in 2015 they have classification of broadband ISPs as similar to public utility services and subject to FCC regulation the reason why they just like try to classify the broadband ISP as public utility is because they will have like the federal law talking about public utility services and then they can apply the broadband ISP to that category as well because otherwise if it's not just promoted as a public utility services the government has to just like set up an extra law and regulation for the broadband ISP so that's why they try to standardize it and in 2016 FCC approved new privacy rules for broadband ISP that those broadband ISP must notify users of privacy options or obtain users' consent to collect their information. Service cannot be contingent on users surrendering privacy. Later on in year 2017, Congress voted to repeal privacy rules for broadband ISP. In each country, when they see this one, they try to just like see and then just evaluate whether this kind of the regulations can be matched with the internet service provider of their countries or not before they can apply this one. Okay, I think in Thailand they don't have this law. The ISP is not defined as a public utility service in law it's just a service of one company only that means they have to just like use the common commercial law apply to that ISP if there's something happen they cannot use like just like the public law like the public utility service apply to the ISP if there's something wrong happen after that for the privacy policies For the privacy policies, it means that when you set up an e-commerce website, you need to have website terms of use notices นะครับ as one section or one link that your consumer can just like access to that part and have a look นะครับ the proper e-commerce site should have this นะครับ Recent studies show that these policies would take average readers 8 hours to read policies. You can see that even though no one wants to read, because if you read, you have to spend around 8 hours to read it, but you need to have it. And also it have conflicting statements inside the privacy policy anyway, if you just read and analyze in detail. And there might be like some little oversight and comparison between policies of different companies นะครับ okay. And in Europe นะครับ for the privacy protection, European privacy protection are much stronger than in US นะครับ because they want to protect individual person นะครับ in 1998 European Commission's directive on data protection นะครับ this one is they set up this commission meeting at Safe Harbor นะครับ Later on in 2016 นะครับ EU has General Data Protection Regulation or GDPR นะครับ This is the privacy shield that okay for the any website who would like to trade or have an or conduct a business with the European people นะครับ they need to follow the GDPR นะครับ and at the very beginning of GDPR they set up a website นะครับ the GDPR website that if you are European customer นะครับ if you are living in Europe countries you can check from GDPR website that this website นะครับ for example the e-commerce website of company A is in the list of GDPR or not นะครับ if that website of company A is in GDPR list that means okay you can just like freely buy or doing the business transaction with the company A because they protect your data นะครับ according to the EU setup นะครับ in here privacy environment has turned against US firm like Facebook an unfettered collection and use of personal data นะครับ so apart from the law นะครับ by the government นะครับ by the country นะครับ or by the group of countries the regulation or the law can be in the same industry นะครับ so in this one we call it as industry self-regulation นะครับ for example in some industry they have the regulation นะครับ for the industry called like privacy seal programs network advertising initiative นะครับ ad choices program นะครับ in general the self-regulations has not succeeded in reducing American fears of privacy invasion or reducing the level of privacy invasion นะครับ so that's why the government in this case is in America they have to just like set up the privacy law นะครับ in the country same as in Thailand ครับ because if we set up the self-regulation for let's say software industry but there will be like some software that has been developed by people who are not joining the software commissioner or something like that and then they don't follow this regulation so if we don't have any law to govern no one controls this one so in order to help นะครับ for the privacy protection นะครับ these are like example of the technology solutions that we may have นะครับ solutions include spyware blockers pop-up blockers and ad blockers secure email anonymous emailers นะครับ cookies managers disk or file erasing programs public key encryption นะครับ none address core issues of consumer privacy นะครับ what information is collected and how it is used by that website or that platform นะครับ and for the consumer's rights นะครับ these are just like the core issues of consumer privacy that we always have to think about when you have to just like set up the e-commerce นะครับ but anyway no one address about this one นะครับ much in terms of privacy protection นะครับ so this one is like we talk about the privacy protection as a business and privacy advocacy groups นะครับ for the privacy protection here นะครับ we talk about in details next in this one นะครับ for the limitation on the right to privacy นะครับ these are just like the case like Edward Snowden versus NSA PRISM program นะครับ this is just like one limitation on the right to the privacy problem law enforcement and surveillance นะครับ USA Freedom Act นะครับ Apple's iPhone 6 and encryption and use of personal data by government agency นะครับ these are example of limitation on the right to privacy that's why นะครับ the company นะครับ who just like try to collect information from users they just like still use like this kind of the right to privacy in order to just like use data นะครับ your data for other purposes and then while the law that they just like try to help protecting the information of the users may not just like be just like used effectively is because like some countries they have the right to the privacy like this นะครับ okay right so these are just like the about the privacy issues นะครับ that we have to think and we have to just like know about it นะครับ actually we have like more things to discuss นะครับ in this part นะครับ on the next class I will talk about the first insight case นะครับ Apple Defender of Privacy นะครับ on the next class we begin with Sujina นะครับ to talk about the insight of the first case and I would like every other students to help answering this class discussion questions นะครับ so because I mean like when you do not need to summarize the case as your volunteer did นะครับ you should just like help us to discuss with this class discussion for the case too